is one on the video conferencing. Dr. Praful Desai case. Another was on the tape recording statement, whether relevant or admissible under the Indian Evidence Act. So that was R.M. Malkani versus State of Maharashtra. So these three cases we have discussed, and after that we discussed section 12, 13, 14, 15, and 16. Okay, though these sections are not in our syllabus, but just to make you aware, we have discussed these sections. Now, today we are scheduled to discuss the next portion, or you can say the next part in the chapter 2, and that is admission. It runs from section 17 to 23. So these sections we have to discuss here. Admission, as the name suggests, means when someone admits something. And when you admit something, we, human being, through the language, through the, statement, whether it is written and oral, we admit. Someone say that, are you living in, or are you teaching in Delhi University? So I say either through orally, yes, I teach in Delhi University, or through the written statement, I write that I teach in Delhi University. So basically, admission is statement. Okay, admission word is, or arises, or it has the origin with admit. Okay, so admission is basically statement. The statement may be in oral form, it may be in documentary, written form, or maybe in electronic records. It is like whatever I'm saying, it is recorded on the electronic media. So that thing. So that common idea we have from the word admission. Now, this is just a layman understanding, but it would be very helpful even to understand further on this point. Now, if someone asks from you that what you understand by the word admission, or how the admission would be, become relevant, because before the discussion of this section, I'm telling you that admission is also relevant, and you can make the inference also, because it is between section 6 to 55. तो relevant का एक section है, तो वो relevancy बता रहा है, तो relevant ही होगा. So my question is that what is your opinion how the admission can be relevant? Yes, guys. Any idea? Admission कैसे relevant होगा? Yes, Mr. Abhimanyu. Mr. Abhimanyu.
Yes, sir.
How admission will be relevant? कोई एक एग्जाम्पल से आप इलस्ट्रेट कर सकते हो, समझा सकते हो? See, it's very simple. Suppose there is a question about those student में झगड़ा हो गया about the title of the book, and Mr. Abhimanyu is saying that this Bear Act is of mine, and Ojasvi carry कि ये Bear Act मेरा है. Okay, अब प्रोसीडिंग होती है. सो सपोज, और उसमें आप ही की क्लास से एक बंदा रामकरण आता है. उसने कहता है कि भाई 3 दिन पहले अभिमन्यु ने कहा था कि ये बेर एक्ट उसके हाथ में था, और उसने कहा था कि ये बेर एक्ट जो है ओजस्वी का है, मैंने उधार लिया है. सो नाउ दिस थिंग that he is admitting that the Bear Act, the property that is in the question, is not of him but of the opposite party. So this is admission, and this is relevant because it has some inference regarding the fact in issue. What is the fact in issue? That who is the owner of this bare act. So admission making some inference toward that. So that's why they are making relevant. Okay. Now come to the section 17, where the legal definition of the word admission is there. See, on the discussion of the admission, three things we will discuss. First is what is admission. The second is that who can make the admission. And the third is against whom the admission can be used. So first is what is admission. Second is who can make the admission, because section 18, 19, 20, these three sections are talking about the person who can make the admission. And section 21 talk about that it can be used against whom. So first is what is admission, second is who can make the admission, and third is against whom the admission can be proved and would be relevant and proved. Okay. See the similar thing in the example that I have given. If Abhimanyu say पहले भी उसने यही कहा हुआ है रामकरण को कि मेरा bare act, so it would not be relevant because it's not having any relevance. Section 21 is making only those admission that is against the party, and that's why maybe it is admission. It is, giving in towards the inference toward the fact in issue, but section 21 say that against whom it can be used. So it would be relevant against the party who made adversely. Okay, come to the section 17. Now, these admissions we are talking about, these are extrajudicial admission. What is extrajudicial admission? Extrajudicial admission means those admissions which are made, outside the judicial proceeding. When the judicial proceeding is going on and then you made the admission, that is judicial admission. ट्रायल चल रही है और फिर उसमें जज साहब ने कहा कि नहीं, and then you admit, okay, ठीक है, ये मेरा bare act नहीं. So that is judicial admission. When you make an admission, outside the judicial process is known as extrajudicial admission. And this, from section 17 to 23 is talk about extrajudicial admission. Now, why the admission are important? And for that, we can relate this part admission to section 58. If you have bare act, you can read section 58, that fact admitted need not to be proved. No fact need to be proved in any proceeding which the parties thereto or their agent agree to admit at the hearing. So this talking about judicial admission. When in the judicial process, when in the civil case, how the civil case started, one person filed the plaint, and that's why he is known as plaintiff. In the plaint, he claims something. Then the opposite party against whom he filed the claim, this plaint, he filed the reply of this plaint, para-wise. So that is written statement, WS, written statement. And there are many things that is admitted by the opposite party, so that become admission. And this admission is judicial admission. In the judicial proceeding, you have admitted it. Suppose in the first para it is written that I am Abhimanyu Kumar living in Flana, Flana, Flana. And the respondent also that he does not deny this name of the person and this. So it is admitted. Suppose he is possessing this property, that is also not denied, that is also admitted. So section 58 talking about the judicial admission, that when there is a judicial admission, that need not to be proved. which later on, I'm reading further on the section 58, or which before the hearing they agree to admit by any writing under their hand, or which by any rule of the pleading in force at the time they are deemed to be admitted by their pleading, provided the court may in its discretion require the fact admitted to be proved otherwise than by admission. But it is discretion of the court. Court may say that they have to prove, the party have to prove, even other than the admission. But otherwise, section 58 is clear that in the judicial admission, there is no need to prove because these facts are not in controversy. Okay. Now come to the extrajudicial confession, to which we are, discussing. Section 17, here, if we rely on the section 58, admission has not to be proved. But when we read inside the section, don't be confused with the marginal note of the section 58 that admission are need not to be proved, or sir ne pura admission padha diya. No, that admission that section 58 is talking about is about judicial admission, the admission that made during the trial or during the formation of the pleading or through pleading that deemed to be proved, that deemed to be admitted in that sense. These admissions are when before the trial, when before the proceeding, when before the judicial inquiry at some other point of time, like for sake of simplicity. Again, I'm dragging these two people, Ojasvi and Abhimanyu. Suppose there is a property dispute between Abhimanyu and Ojasvi. And with respect to that property in dispute, some years back, there is another case. And in that case, suppose Abhimanyu has admitted in the court that yes, this property is of Ojasvi. Okay, some other case. And same property is in the issue now. Now, this would be admitted. I'm not talking about that is same case and the res judicata, not in that sense. Okay, so that would be admitted. Okay, so this is extrajudicial admission we are talking about. Now come to the section 17, the admission defined. Marginal note says admission defined. An admission is a statement that we already, got the idea from our layman discussion that आप admit करोगे तो किसी orally होगा या document के through होगा, written में होगा या आप electronic medium से करोगे, that would be present in electronic records, but it is admission. It is not an act, it is admission. Admission is a statement. An admission is a statement, oral, documentary, or contained in electronic form. Okay, which suggest any inference as to the fact in issue or relevant fact, and which is made by any of the person and under the circumstances hereinafter mentioned. So section 17 is clear on the point that it is statement. It may be present in oral form or the documentary or in the electronic record. And the feature of this statement is that it has inference towards the fact in issue or the relevant fact. Okay, either that fact is already itself in the question, or it is relevant fact. Admission are applicable to civil cases as well as in the criminal cases. So suppose with respect to the stolen property, there is a question that Mr. A has received the stolen property and so committed the offense of section 411 of Indian Penal Code. 2 days before he was arrested, or before this whole thing was done, Mr. B visited to A house and said that, oh, आपने तो बहुत अच्छा एसी खरीदा. उसने कहा नहीं भाई साहब ये तो चोरी का था, बड़ा सस्ते में मैंने खरीद लिया. So this statement is admission about this thing, that it is stolen property and he know that it was stolen. Now, this statement of Mr. A is making the inference in the fact in issue. And what would be the fact in issue in the trial when the offense is under section 411? That first, receiving the stolen property. So receiving the property, stolen property, and second is that he has the knowledge that it is stolen property. Without mens rea, the act is receiving the stolen property, and the mens rea with the knowledge that it is a stolen property. And so this admission that it is stolen property and that's why I got it at the cheaper price is making the inference with respect to the second fact in issue, that is that he has the knowledge, he had the knowledge at the time of purchase that it was stolen property. Okay, so that is the thing. But this definition under section 17 is not complete because it is not clear that which is made by any of the person as hereinafter mentioned and by under the circumstances here as hereinafter mentioned. So who can make the admission and under which circumstances they can make the admission, this section is silent and referring to the some other sections, section 18, 19, 20, etc. And so in that sense, section 17 is not a complete section. It is an incomplete section because it does not mention the person by whom admission is made or the circumstances under the admission is made. But when we later on 3 sections we will discuss that related to who can make the admission, section 18, section 19 and section 20. First would be the person who can make the statement, the party to the proceeding. Second, अगर उसके representative ने हुआ. Third, suppose it is a representative suit under order 1 rule 8 of the CPC. Order 1 rule 8, 5-7 लोगों का कॉमन इंटरेस्ट है और रिप्रेजेंटेटिव सूट है, आप सब लोगों को रिप्रेजेंट कर रहे हैं, नॉट पब्लिक इंटरेस्ट लिटिगेशन, रिप्रेजेंटेटिव सूट अंडर ऑर्डर 1 रूल 8 ऑफ द सिविल प्रोसीजर कोड. So the person in the representative capacity make, that would also be admission. The person who have joint interest, 5 भाइयों की ज्वाइंट प्रॉपर्टी है, एक भाई जाके एडमिट कराया भाई ये तो हमारी प्रॉपर्टी नहीं है, ये तो हमने चाचा से जो है विल फॉर्ज करके ली थी. एडमिशन because they have common interest. So the persons who have the common interest, if the admission is made by any one of them, or the person from whom you have inherited the property, like the property you have inherited from father, and father already admitted that this is not my property to somewhere else, to someone. This is something that I got by forging the deed or by illegal possession, etc. So that is also. You have not admitted, but the person from you have derived this property, who had admitted this. And the next is referee. आपने कहा कि किसी ने पूछा ये पेन आपका, ये तो मुझे चोरी का लग रहा है, तो आपने भी जोश जोश में कह दिया कि जाके पूछ लो अभिमन्यु से. अब अभिमन्यु इज वेरी ईमानदार आदमी, उसने कहा कि नहीं सर के हाथ में पेन तो है बट ये है नहीं, ये सिद्धार्थ का है. So now I am not saying that this pen is not mine, this pen is of Siddharth, but I refer to Abhimanyu and Abhimanyu said that, and so his admission would be used against me. That would also be the admission. So these are the certain person who can make the admission. The first section I am taking is section 18. Admission by party to the proceeding or his agent. Statement made by a party to the proceeding or by an agent to any such party whom the court regard under the circumstances of the case as expressly or impliedly authorized by him to make them as admission. So first is statement made by party to the proceeding. जो प्रोसीडिंग की पार्टी है ईदर साइड उन्होंने कोई स्टेटमेंट मेड किया है दैट हैविंग द इन्फ्रेंस towards the fact in issue or relevant fact, that would be admission or by his agent. So the first part of the section 18 cover two types of the person. First is the party to the proceeding and second the agent of that party. Okay, the next part, the second part is by shooter in representative character. And here you can write order 1 rule 8 of the CPC, because second part is basically related to the party in the representative capacity. Statement made by the parties to the suit suing or sued in a representative character, या आप शूट किया हो या आप दूसरी साइड से हो, डिफेंस साइड से, डिफेंडेंट साइड से, are not admission unless they were made while the party making them held the character. So suppose you are the representative of 8 person in your society, filed the case with regard to the street. You are the representative, your admission, your statement would amount to admission, but the rest of 7 person would not amount to admission. Section is very clear. Statement made by the parties to the suit, suing or sued in representative character, are not admission unless they were made while the party making them held that character. Held that character means held the character of representative. Okay. Now, third part, statement made by, ये part वाट लिख नहीं रखा, और just our convenience we are saying इन हिस्सों में है, that's why we are saying part 1, part 2, part 3. It's not written there part 1. You can write it by pencil or pen. Statement made by party interested in subject matter. As I gave the example, 5 brothers having a property, common property, and one of them have made a statement with respect to the title of that property, and then later on when there is any proceeding with respect to the title of that proceeding, the statement of this person, because here all the person are in the party to the suit. They are interested, they are not in representative capacity. So party interested in subject matter, person who have any proprietary or pecuniary interest in the subject matter of the proceeding and who make the statement in their character of the person so interested. So the parties who are interested, pecuniary, proprietary or pecuniary interest in the subject matter and make the statement would also be relevant, would also be admission. 2, person from whom interest derived. Person from whom the parties to the suit have derived their interest in the subject matter of the suit are admission if they are made during the continuance of the interest person making the statement. So suppose as I gave the example कि आपने अपने फादर से प्रॉपर्टी इनहेरिट किया है एंड आपके फादर साहब ने तो कुछ ऐसा एडमिशन, कुछ ऐसी स्टेटमेंट दी है जो उस प्रॉपर्टी के टाइटल या जिससे रिलेटेड सब्जेक्ट मैटर है, इशू है, उसकी तरफ इन्फ्रेंस करती है. ओके, सो इफ ड्यूरिंग द कंटिन्यूएंस तब भी वो आपके पिताजी के पास वो प्रॉपर्टी एज ए मैटर में थे और उस समय अगर वो हुआ हो, so that statement would also amount to admission. Okay, so here 1 2 3 4 5 type of the person this section 18 covers. The first is party to the proceeding. Second is agent authorized by such party to the proceeding. The third is party representing in the representative suit. The fourth one is person jointly interested. And the fifth one is the person from whom the party inherited the property. Okay, so these are the five persons that section 18 covers who can make the admission. Now come to the section 19. Admission by person whose position must be proved as against party to the suit. Admission by person whose position must be proved as against the party to the suit. Now, the section states that statement made by person whose position or liability it is necessary to prove as against any party to the suit are admission. So any person whose position is necessary to prove, उसकी statement भी admission होगी. If such admission would be relevant as against such person in relation to such position or liability in a suit brought by or against them, and if they were made whilst the person making them occupy such position or subject to such liability. Maybe this section is, seeming you are very complex, but when you read the illustration, you feel that it is very simple. होता है ना कई बार चीजें इंग्लिश में बताने में, अब उसको पूरा बताने में look very complex, but when you give the example, it becomes simple. A undertake to collect rent from B. A B ने बंदा हायर किया हुआ है A, और A की ड्यूटी है कि वो रेंट कलेक्ट करेगा. जो अपने मूवी नहीं देखी जिसमें प्रेस रावल होता है और दिस नाना पाटेकर, तो नाना पाटेकर को रख लेता है कि आप रेंट कलेक्ट करोगे पूरी बस्ती को, और फिर वो कलम वाली बाई रेंट नहीं देती है. सो ऐसी सिचुएशन, A undertake to collect rent from B and B ने A को sue कर दिया कि that he is not doing his duty properly, he has not collected rent that was due from C. C से जो ड्यू था B को, उस रेंट को इसने कलेक्ट नहीं किया. A कहता है नो नो, C का तो कलम वाली बाई का तो कोई रेंट ही नहीं है, C is this कलम वाली बाई. So A denies that rent was due from C to the B. कलम वाली बाई यहाँ पे गेम खेल गई. A statement by C that he owes B rent is an admission and is relevant fact against A if A denies that C did owe rent to B. So the statement of C that he owes the rent to B would be against Mr. A. Okay, so that's the section 19 covers it. Now come to section 20. Section 20 is admission by referee. Admission by referee. When without saying you refer to some other person that go and ask from him, and when that person give the statement that as according to section having any inference with respect to the fact in issue or relevant fact, that would be admission. So the statement made by a person to whom the party to the suit has expressly referred for information to a matter in dispute are admission. The question is whether a horse sold by A to B is sound. The question was whether a horse sold by A to B is sound. पहले घोड़े बिकते थे, that's why this such type of illustration is there. The question is between A and B. कि A ने B को घोड़ा बेच दिया, बाद में B ने केस किया कि नहीं सर घोड़ा तो वो पागल था. And in the question was that in the suit there is the issue that B, with the knowledge that the horse was unsound, sold to A denies no. I did not know this. And the question is whether horse sold by A to B is sound. Okay. So suppose when this whole thing is done, A says to B, go and ask C. C knows all about it. C उसका खास दोस्त रहा होगा, but C ने poll खोल दी, and thus C said that no, horse was unsound. So whatever he said, if it has related to any inference to fact in issue or relevant fact, it would be an admission. Okay. Now there is one another thing that I want to clarify. If you read the first line, the statement made by a person to whom a party to the suit word is written. And so it gives the inference that this provision is related to only, civil proceeding. But it is not so. If you refer the Munir book, he says that it is applicable even in the criminal cases also. And for that he had given the example, the rule which make the admission by a referee admissible against the referee applies to the criminal cases as well. Thus, where the accused told a constable that his wife would make out the list of the certain property, a list afterward made out by her was held to be admissible against her husband, and this was in case R versus Mallory. R versus Mallory. Okay. According to Section 20 of the Evidence Act, if party to the suit agree to be bound by the statement of fact made by the third party, the statement of third party, when made, is to be treated as admission by the party who made the offer, and if bound, if both the parties agree to refer a matter to the third party, his statement will be binding both on the parties. Is it clear? And so from here, the second question, the first question is what is admission? We have discussed. The second question is who can make the admission? From section 18, 5%, from section 19, 1%, and from section 20, 1%. So total 7 type of the person can make the statement. We can again, revise that. First is the party to the proceeding, agent of the party, authorized agent, then representative in representative suit, then the person who is interested as a pecuniary or the proprietary interest, or the person from whom you have derived the subject matter, or the person whose position or liability is necessary to prove against the party to the suit, and the 7th one is referee. So these are the 7 person whose statement would be admission if they are fall under section 17, that means having inferring towards the fact in issue or the relevant fact. Okay. Now come to the second thing, that against whom it can be used, or the circumstances. If you see from the section 17, under the circumstances which can be made, or under the circumstances hereinafter mentioned. That's why we said that section 17 is incomplete, so that circumstances are later on. But before that, there is another question. There is another word that you have read, you have listened, that is confession. And the question is how the admission is different from confession. What is confession? When a statement would be considered as confession, because it is very, very important. Why? When you read this, interesting case of Agnu Nagesha versus state of Bihar. This person in his village, he killed his auntie and some other family members, सबको मार पीट के काट के, and then he went to the police station and he made confession कि साहब ऐसे ऐसे था, मैंने सबको काट दिया, मार दिया, and he got free, acquittal, because of the section 25. The confession made before the police officer is not admissible. It is relevant but not admissible, expressly held to be not admissible. And so the rule from section 25 to 30 applicable to the confession, and from 17 to 23 the rule applicable to admission. And that's why it's very, very important to demarcate between the admission and the confession. There is always a confusion about the word confession because confession has not been defined in the Indian Evidence Act. प्रोविजन है, कन्फेशन होती क्या है भाई साहब ने डिफाइन नहीं किया. सर जेम्स फिट्स स्टीफन कहाँ गए? So the problem is that the confession word has not been defined, and that's why it's very, very difficult that what is confession. And the important judgment that we have from the Privy Council, the highest judicial body at that time before our constitution came into force. AIR 1939 Privy Council 47. AIR 1939 PC 47. Name of the case is Pakla Narayan versus Emperor. And here it has been defined. This thing that you can find in your case material also is on the page number 56 in CBI versus VC Sukla. Confession must either admit in term of offense or at any rate substantially all the facts which constitute the offense. So confession is either admit in term of offense or at any rate substantially all the facts which constitute the offense. So suppose there is the issue. So suppose in the murder trial, the allegation is on the party, is on the person A. And A says that, yes, I murdered B. This is confession. If A say कि उस रात को 12 बजे की रात को मैं गया and I saw that A was drinking. So किसी past की बात करने के लिए मैं गया था. And then with knife 3-4 times I stabbed to this person. And medical report says that the knife is same, and with this stabbing, with lot of blood was flown out, he was killed. So either he admit in term of the offense or at substantially rate all the fact that constitute that I was intended, I caused the injury, and medical report says that because of that injury he was called. If that is not done, that would not be an confession, how so much it is incriminating. And very, very beautifully Privy Council in the latter line, you can find on page number 56 of your case material, that an admission of gravely incriminating fact, gravely incriminating, बहुत ज्यादा आपने अपने आप को criminalize करने की तो fact भी बता दिया. Even a conclusive incriminating fact is not itself a confession. Howsoever grave in admission, howsoever conclusively incriminating fact is not an admission. And they have given the example also. An admission that accused is the owner of and was in recent possession of knife or revolver which caused the death with no explanation of any man other possession would not be confession. आपके पास वो रिवॉल्वर मिला जिससे गोली चली थी, ballistic report, everything that is, and there is no possibility that some other person also get possession of that. Very incriminating fact. You admit it, हाँ मेरी revolver है साहब, but this would not be confession, because ना तो आपने ये एडमिट किया या आपने मर्डर किया, ना आपने ये एडमिट किया कि आपने इंजरीज कॉज की और मेडिकल रिपोर्ट में फिर उन इंजरियों के कारण। सो ना तो आपने एडमिट इन टर्म ऑफ ऑफेंस किया, ना आपने सब्सटेंशियली रेट पे सारे फैक्ट को एडमिट किया जो कि ऑफेंस को कॉन्स्टिट्यूट करता है। एंड सो इट इज नॉट confession, it is admission. Rule from section 17 to 23 would apply. Later on in Palvinder Kaur versus State of Punjab, Om Prakash versus State of UP, Veer Ibrahim versus State of Maharashtra, it would same applied. And in this case, even the Munir law of evidence was also referred, because it's very, very important. Now there is very important case, Parliament attack case. That is in the state NCT of Delhi, National Capital Territory of Delhi versus Navjot Sandhu. The Supreme Court made a distinction between confession and admission. The court observed that an admission is a statement, oral or documentary, which enables the court to draw an inference as to fact in issue and relevant fact. It is tried to say that every confession must necessarily be an admission, but every admission does not necessarily amount to confession. A confession is an admission made at any time by a person charged with crime, standing or suggesting the inference that he committed the crime. An admission made in the pleading is not treated as the same manner as the admission in a document. An admission made by party to his list is admissible against him proprio vigro. Now there is another thing, and that was in the case of Bal Gangadhar Tilak versus Sri Nivas Pandit. You can write also the name of case. Bal Gangadhar Tilak, BGT, Privy Council decision है. Bal Gangadhar Tilak versus Srinivas Pandit, 39 Bombay 441. See, there is one section 145, and under section 145, to impeach the credit of a person, the previous statement can be made. And the purpose of that previous statement only to impeach the credit. जैसे आपको एज ए विटनेस प्रोड्यूस किया और आपने कहा कि मैं जी रोहिणी में रहता हूं और मेरे सामने की गली में ये लोग रहते हैं, एंड देन द प्रीवियस स्टेटमेंट कैन आल्सो बी प्रूव्ड वेयर यू हैव सीन दैट आई एम रिजाइडिंग सम सपोज इन द द्वारका, जस्ट टू इम्पीच द क्रेडिट, ताकि जो आगे भी आप जो बताने जा रहे हो ना उस पर भी जज साहब यकीन ना करें. So just to impeach the credit, section 45 is there where the previous statement can be used. But admission is not in that nature. And the case that we have in our case material, that was, the judgment was authored by Justice, just give me 1 second. I just forget. Yeah, we are Krishna here. So Vishwanath Prasad versus Dwarka Prasad. Vishwanath Prasad versus Dwarka Prasad. On the para number 8, page number 47. There also there is a distinction between section 145 of Evidence Act and this confession. And in Bal Gangadhar Tilak versus Srinivas Pandit also. And so the court said that an admission is admissible proprio vigor, P-R-O-P-R-I-O, proprio vigor, and given in evidence as substantive evidence, मतलब proper, and not for contradiction purpose. And so certain document when used and relied on its an inference drawn by them by the Bombay High Court to discredit the evidence of the witness in the case without these document or inference drawn from them being put in the to them, this was held to be contrary to the section 145, which provides that when it is uh, intended or contradict the witness of the previous inconsistent statement of his, attention must be drawn to the party to the statement. So question is that you are saying the previous statement, when you are introducing the previous statement, that was the question in this case also, where the Justice V.R. Krishna Iyer wrote the judgment that, sir, this is something that previous statement, and so the previous statement must be put before the witness. No, this is the admission, and it is not under section 145. And admission is the substantive. The admission is the substantive evidence. It is proprietary vigor, and it is different from the section 145. There, the purpose of the earlier statement is just to breach the credit of the witness. Here, it is an admission as a substantive evidence against the accused, against the person who is in the party. Okay, so that's the thing. Now, with this, come to the next provision, section 21, or to the next answer to the question that against whom it can be used. Or if you see in the language of section 17, under which circumstances it has to be made. Okay. Section 21, proof of admission against the person making them and by or on their behalf. Admissions are relevant. इतना ही काफी है. Relevant है तो section 5 में prove भी करेंगे, लेकिन फिर भी by way of precaution legislature has said and may be proved. Otherwise इस वर्ड की कोई जरूरत है नहीं. May be proved. When something is relevant, section 5 says that the evidence of a fact can be given that is relevant, and the section 21 is making this fact as relevant. So evidence can be given by virtue of section 5, but it is written and may be proved as against the person who makes them or his representative in interest. Now see, the answer is complete. What is admission? Admission is a statement. It may be in oral, documentary, or electronic form. So admission is a statement. It has to be made by any of those 7 parties that mention in section 18, 19, and 20. And this statement have inference towards the fact in issue or relevant fact. And this statement is made if it is against the party who is making it. Against means in that suit, if it is used as adversary. So if it is against the person who make them, yes, Mr. Ramkaran, yes. Yes, Mr. Ramkaran.
सॉरी सर, वो वैसे ही हो गया था.
अच्छा, वैसे हो गए. चलो कोई नहीं, खाली टाइम में आप देख लो कैसे हाथ उठता है किससे. वेरी इंटरेस्टिंग है. या so the it is made by the person who against, if it is against his interest or his representative in interest. So only the adversarial statement has to be proved. So suppose earlier also, suppose there is a question with respect to a particular property in the court. You say that this is my property, I inherited from my father. And Mr. Mahashay A says, nahi, this is my property, and case chal raha hai. And now you want to prove an earlier statement कि जी मैंने जब बिल बनवाया तब भी उसमें लिखा था कि ये मैंने परचेज, ये मेरी फादर से इनहेरिट हुआ है और इसके ऊपर मैंने बिल बनवाया इलेक्ट्रिसिटी का. That would not be, because it is not against you. या कोई आपके घर पे मेहमान आया, उसे भी कहा कि हाँ भाई साहब बड़ा प्यारा घर है, आप यू सेड दैट ओके हाँ हाँ भाई फादर साहब से इनहेरिट किया है. इट कैन नॉट बी. इट इज आल्सो ए स्टेटमेंट. ये भी इन्फ्रेंस दे रहा है कि घर किसका है, भाई आपका है, बट ये नहीं यूज होगा. अगर आपने ऐसा कहा है कि नहीं भाई साहब ये नहीं है, ये तो बगल वाले का था, बस ऐसे कर करा के तकड़मबाजी, आई गॉट इट, दिस इज यूज्ड. स्टेटमेंट ये भी है, ये भी इन्फ्रेंस दे रहा है, उसमें भी इन्फ्रेंस है, उसमें आपके फेवर में दे रहा था, इसमें आपके अगेंस्ट दे रहा है. बट द स्टेटमेंट that is as per the section 21 is against the party who make it is relevant, and that's why section 17 is not complete in that sense. Or maybe it is the intention of the legislature that section 17 only describe the admission thing. Admission तो दोनों हैं, but with respect to the relevant part of relevant admission, section 17 definition is not complete. So that way also we can see. Okay. Now come to the next line of the section 21. But they cannot be proved by or on behalf of the person who make them or his representative in interest, except in the following case. So admission are relevant and may be proved as against the person who makes them or his representative interest. That is, that the statement, the admission that a party made against him may be proved, but the party who made in his favor would not be relevant. But there are 3 exceptions. But the exception in the strict sense, they are not exception. In the strict sense, the 3 clauses in section 21 is not talking about that ye admission tha to prove. These are saying that if the admitted statement are relevant with some other section, then it would be admissible. Then you cannot say that nahi admission है section 21 वहां पे बार लगाया हुआ है. And so in the strict sense, the exception for those statement that can be proved, or those admission that can be proved that a party made in his favor, not against, in his favor. So the section 21 is in 2 parts. One, that admission are relevant only when that admission is made against the party who made it, and the admission by the party in his favor is not relevant. Okay, these are the 2 things. Now in his favor can be relevant under these 3 exceptions, but when you observe these 3, you will find that as an admission they are not relevant, they are not made relevant, but because they are falling with some other section, that's why they are relevant. Okay, so आप ये भी कह सकते हो there are 3 circumstances under which admission by a party in favor of him would be relevant. और ज्यादा स्कॉलरली कहो तो ये भी कह सकते हो that admission against the party is relevant, but admission in favor of the party would become relevant when they are relevant under some other provisions. Now come to the first clause. An admission may be proved by or behalf of the person making it when it is of the such nature. If the person making it were dead, it would be relevant as against third person under section 32. So it is referring to dying declaration, DD, dying declaration. यहाँ डिमांड ड्राफ्ट नहीं होगा, dying declaration, DD. So if the statement is made by a person and whose statement would amount to dying declaration, so that is also an admission. But as an admission and it is made in favor of him would not be relevant. But because now that person who made the statement is no more, and so it would be relevant because it fulfill the requirement of section 32 clause 1. So there it is relevant. So it would be relevant, though it is also in nature of admission. So in nutshell, you can say that the basic purpose behind the section 21 letter part is that if we write that admission by a party against his interest would be relevant and in his favor would not be relevant, it would may cause the confusion, because then the lawyer said कि आपने डाइंग डिक्लेरेशन में ये कहा कि ये रिलेवेंट है, नहीं नहीं एडमिशन में तो सेक्शन 21 में इट इज नॉट रिलेवेंट, सो देयर इज अ कॉन्फ्लिक्ट. So just to remove that conflict, there is this provision. Second is, an admission may be proved by or on behalf of the person making it when it consists of a statement of existence of any state of mind, body, relevant or in issue made at or about the time when such state of mind, body existed and is accompanied by conduct rendering it falsehood improbable. So it's about the natural situation where the statement would not be cannot be false, because it is made under that situation. And this illustration D explain it perfectly. Read illustration D, that A is accused of receiving stolen goods knowing them to stolen, offense of section 410, punishment under section 411. So section 411 talking about the punishment or the receiving the stolen property knowing them to be stolen. A, he offered to prove that he refused to sell them below their value. वो ये प्रूव करना चाहता है कि जी ये चोरी की नहीं थी और मैंने अगले को एक पर्टिकुलर प्राइस से नीचे बेचने को मना कर दिया. कि A may prove these statement though they are admission because they explanatory of conduct influenced by fact in issue. What is fact in issue? That he knows, he has the knowledge that they are stolen property, but because he want to prove this conduct, and this statement amount to the admission of the fact that he did not know, he did not have the knowledge. So this is in favor of him, but this is in favor of him as under admission it is not admissible, but because the statement is explanatory of the conduct. Exception 2 says that admission may be proved by on behalf of the person making it if when it consists of a statement of the existence of any state of body or mind, the mental thing that he had the knowledge, when such state of mind existed and is accompanied by conduct, and this conduct of not letting him to sell at a lower price is making this falsehood as improbable that he has the knowledge or he has that thing. Okay, so that's the solution. And the third one is, an admission may be proved by or on behalf of the person making it if it is relevant otherwise than an admission. Otherwise means if it is a part of res geste, section 6, section 7 also, section 14 में भी जो previous things हैं, section 34 भी conduct transaction records का part है, that also be in favor of that person can be used. But there are two more sections, section 22 and 23. I just want to take these also. There is section 59. See the documents, if you see the evidence in the section 3, the evidence have two types of evidence. All statement, that means oral evidence, all document that that includes the electronic records. Okay, so these are the two things: oral evidence and documentary evidence. And documentary evidence itself includes the electronic record. Now, with respect to the documentary evidence, there is this chapter 5, and with respect to the oral evidence, there is chapter 4. In the chapter 4, there is this section 59, that proof of facts by oral evidence. And this section says all facts except, I will not read that except now, all fact, then the except, and then there is some line, and then the comma, may be proved by evidence. So section 59 is very wide, that कोई भी फैक्ट हो कि उसने उसको मारा, उसका मोटिव क्या था, उसकी इंटेंशन क्या थी, प्रिपरेशन का एविडेंस हो, उनकी कॉन्स्पिरेसी का एविडेंस हो, व्हाटएवर दैट, यू कैन प्रूव बाय ओरल एविडेंस. तो ये एक्सेप्ट क्या करता है? So in exception it is said that the content of the document or the electronic record, डॉक्यूमेंट में क्या लिखा हुआ है और इलेक्ट्रॉनिक रिकॉर्ड का कंटेंट क्या है, इसका प्रूफ जो है वो ओरल एविडेंस से नहीं प्रूव किया जा सकता. दैट इज बेस्ट एविडेंस रूल और कार्डिनल प्रिंसिपल ऑफ एविडेंस आल्सो यू कैन से. सो सपोज बिटवीन पर्सन ए एंड पर्सन बी देयर वाज ए कॉन्ट्रैक्ट. आप उसकी गवाही दे सकते हो, हाँ जी कॉन्ट्रैक्ट था, दोनों एग्री थे, बट कॉन्ट्रैक्ट में एक्चुअली क्या लिखा है, फॉर दैट यू कैन नॉट गिव द एविडेंस. फॉर दैट लेट द डॉक्यूमेंट टू बी प्रूव्ड. डॉक्यूमेंट देख लो, जैसे आप खुद देख लेंगे कि क्या लिखा हुआ है. ओके, but in the chapter 5 later on you will find that documentary evidence is divided into two, primary and secondary evidence. So primary evidence, the document that is in the question, but suppose document ही खो जाए या document दूसरी पार्टी को हो, वो दे नहीं रहा हो, in that situation there is the possibility of giving secondary evidence. And in secondary evidence section 32 section 63 clause 5 is also talking about oral account of the content, but that is just an exception when the primary evidence is not possible. So sometimes the student get confused as section 65, section 63 clause 5, this is written oral document, the oral account of document, and section 59 is talking about that oral evidence of content of the document may for that it may not be proved. So that, and so with respect to the section 59, section 20 and section 21, 22 clause A is drafted. Section 20 is talking about that when oral admission as to the content of document are relevant. Oral admission as to the content of document are not relevant because it is not in the line, it is not in the spirit of section 59. जब हमने oral admission जो है जब हमने oral जो एविडेंस है उसको डॉक्यूमेंट की कंटेंट प्रूव करने के लिए उसको हमने सही नहीं माना है, तो उसको एडमिट करने के लिए कैसे मान सकते हैं? And so the oral admission as to the content of document are not relevant unless, because as such also section 59, the fact may be proved by oral evidence, but the content of document cannot be proved by oral evidence. But section 63 clause 5 says that when the primary evidence is not as a secondary evidence, oral admission, oral evidence of the content of the document is used. So similarly, the latter part of section 22 is that until the party proposing to prove them shows that he is entitled to give secondary evidence of the content of the document under the rules hereinafter contained, or unless the genuineness of the document produced in the question. So that means it is referring to the section 63 clause 5, that if under section 63 clause 5 as a secondary evidence you are able to give the oral account of the content of the document, so in that case also the oral admission would also be relevant as to the content of document, otherwise it would not be relevant. Similar is on the electronic record. पहले तो section था नहीं, but when the Information Technology Act 2000 was enacted by the Parliament, then there was the amendment in IPC and the Indian Evidence Act CRPC also. So in Indian Evidence Act section 22A was written कि भाई अब एविडेंस इलेक्ट्रॉनिक रिकॉर्ड्स के फॉर्म में हो गया तो इलेक्ट्रॉनिक रिकॉर्ड के कंटेंट भी ओरल में नहीं होंगे. When oral admission as to the content of electronic record are relevant, oral admission as to the content of electronic record are not relevant unless the genuineness of the electronic record produced is in the question. Same thing that is in section 21. If the genuineness is in a question, or in the section 22, if the party is able to give the evidence under section 63 clause 5, then it would be admissible. Then section 23, that is known as no prejudice clause. No prejudice clause, you can write it, no prejudice clause, and it is applicable only in the civil cases. It is applicable only in the civil cases. Just give me 1 second. Yes. Admission in civil cases when relevant. In civil cases, no admission is relevant if it is made either upon the express condition that evidence of it is not to be given, or under the circumstances from which the court can infer that the party agreed together that evidence of it should not be given. Explanation. Nothing in this section shall be taken to exempt any barrister, pleader, attorney, vakil from giving evidence of any matter for which he is compelled to give evidence under section 126. In the civil proceeding, sometime during the compromise or times you say that you have to tell the true story, etc. Or suppose in the compromise itself, it is based on the some admission. But in that admission, there is express condition that this would not be used in the evidence. Okay? So that statement would not be used as an admission. So suppose there is a dispute between A and B, and this dispute was settled when the A admitted that it was not, that it was B admitted that it was not his property, and then there is another case. In that case, this earlier statement in this judicial proceeding would not be amount to admission. It cannot be proved because it was on that express condition. But then under section 126, his pleader, his advocate, there, if they are compelled to give the evidence, and that is also in the form of admission, that could be possible because they are authorized agent. Okay, वकील साहब भी तो authorized agent हो जाते हैं. So the professional communication that made under section 126. So as such, professional person has not to make the communication that is between him, but earlier thing can be made, so that when we will read section 126, it would be clear. So for that, this section would not apply. So basically, it no prejudice is known that when you are making the settlement in the court and itself you are admitting something, and then you should write that it would not be used in the further thing. Like, when you give your identity card, your Aadhaar card, etc., you have to write it that it is only for purpose of getting SIM, or it is only for this, that. So similarly, the section 23. Okay. Now, with these sections, we have completed those 3 questions from where we have started our discussion. The first question was, what is admission? And on that, we have learned that from section 17 and combined with the other section, the admission is a statement, and this statement has maybe in form of oral, documentary, or electronic record. Second thing is that it has inference towards the fact in issue or the relevant fact. And the third is that it has to be made by the such person as may be mentioned hereinafter. So the second question answer also comes under that against whom, now who can make it. So those 7 persons. First, the party to the suit. Second, the authorized agent to the party. Third, the person who is in the representative capacity. Fourth, the person who is interested as a proprietary or pecuniary. Fifth is the referee. Sixth is the whose position has to be proved in the suit. And the seventh is about that I think referee. The seventh is the person from whom you derived your interest. Sorry. So these are the 7 persons. And then in section 21, that these has to be made against, if it is against, if this inference, if this statement, if this admission is against the person who made it or his authorized agent or his representative in interest, then these statements are proved. These statements are relevant and can be proved. And the statement, the admission that you have made is not against you, it's in favor of you, you cannot prove. But if even if it is in favor of you, in 3 situations you can prove it. If this admission is in such a situation that it would amount to dying declaration, the person who made it is no more, so it would be in that form of dying declaration, DD under section 32 clause 1, it would be relevant. Though it is also the form, it is also the admission, it is also in favor of you. Second is that when admission is proved on behalf of the person who making in such a situation with the conduct that it falsehood is improbable. So with the statement there must be a conduct, and that conduct showing that the statement what he is saying cannot be false. And the third is that if the statement is otherwise relevant as the part of res gestae under section 7 and under section 14, section 34, etc., then this oral admission that you are talking about, that having inference towards the fact in issue or relevant fact, this inference, this statement, as in line with the section 59, that all fact may be proved with the oral evidence except the content of document. So in the same line, ये statement जो आपने बोला है, ये admission relevant होगा, but it must not be related to the content of the document or the intent of the electronic record, unless it is related to the genuineness. So उसके genuineness से related question हो तब हो सकता है, या उसके you are able to give the secondary evidence under section 63 clause 5 for at the genuineness of the document. And then in the civil cases, the admission if is made with the express condition that it would not be used, then also it would not be relevant, it cannot be made. So with this we have discussed at the length all the sections, and now in the next class we will discuss the cases that are in the on the admission. Another thing that we have discussed from the 2 important cases, one is NCT of Delhi versus Navjot Sandhu, the parliament attack case. Before that, Pakla Narayan Swami versus King Emperor and Palvinder, etc. That there is difference between admission and the confession, and that is important because all the confession are admission, but all the admission are not confession. Only those admission are confession that either the accused admit in term of the offense कि चोरी हाँ जी मैंने चोरी की, murder हाँ जी मैंने murder किया, or admit all the fact that constitute the offense. हाँ जी मैंने उसका सामान उठाया, हाँ मेरा मन में आ गया था कि मुझे सामान उठाना, yes it is theft. जी वो मन से मत कहो कि मैंने चोरी की, जी मैं उस दिन जा रहा था, मैंने देखा there is a beautiful umbrella और मैंने वो umbrella जो है सोचा यार मेरे पास भी होना चाहिए, तो इसलिए मैंने ले लिया. होगी ना? So that's it. And then with respect to the section 145, that admission is not in the nature of section 145, the previous statement to breach the conduct, the credit of the person. So Bal Gangadhar Tilak versus Srinivas Pandit. These are the substantive evidence, proprio vigor. So these things we have discussed. Now in the next class, we will discuss the cases that are based on admission, and with that, this particular subtopic will be over. Now, if you have any question, any query, any issue with respect to the section with respect to admission, you are welcome to ask.